Right. Well, I'd like to welcome everyone to this Quadrant Chambers webinar. I think the topic should require no introduction, as the events in the Red Sea and wider Gulf area obviously continue to have a very significant impact on global shipping. In terms of our speakers and the issues we're going to cover today, we're very privileged to have two guest speakers with us. Firstly, Victoria Mitchell, who is a maritime analyst working for Control Risks in Amsterdam, is going to provide an update on the current position on the ground. Obviously, the position in the Red Sea and the Gulf is a rapidly evolving one. Then Marie Kelly, who is Vice President Defence Global with P&I Club Gard in London, will provide an overview of the sorts of issues and practical problems that are being raised by ship owners and charterers, and which P&I clubs are having to deal with at the moment. Then we'll look at some of the legal issues that arise in a little more detail. So Tom Macey-Dare, KC, will analyse the broad legal framework and identify some of the key principles that need to be taken into account when considering owners and charterers' rights and obligations in relation to a transit through a war risks area. Then Joe Gourgey will look more closely at two of the most widely used war risks clauses, void war and con wartime. And then I will discuss some practical matters in relation to the application of those clauses within the framework that Tom has discussed. So just a couple of points of housekeeping. There is a Q&A function on the Zoom platform. If anyone has any questions, please do type them into that Q&A window, and we'll try and get through as many as we can, either during the course of our talks or at the end. And this webinar is being recorded and will be available to view on the Quadrant Chambers website and YouTube channel after the event. So that said, I'll hand over to Victoria to update us on the current situation on the water.
Thanks so much, John. So I'd like to just begin with a base point just to highlight the geopolitical background to the current situation in the Red Sea. And that's just to say that the group targeting shipping in the Red Sea should be understood as a highly organized militant group with significant control over areas of territory within Yemen. And importantly, that provides them with leverage and reach over a great area of the strategic Red Sea route. And for context, following the commencement of the Israel-Hamas conflict, this group came out in support of the Palestinians in Gaza and said that they would be targeting Israel until that conflict was ended. And so an early demonstration of their capacity included firing of missiles towards Israel, and some of these were shot down by US naval forces, indicating their capacity to operate across the Red Sea. The shifting risk to vessels began in early November, when on the 13th of November, the rebel Houthi movement stated their intent to target Israeli-linked shipping. Now, I'm sure many attendees of this webinar will immediately understand how complex a question Israeli-connected shipping is, but of course we can understand that to include things like Israeli ownership, Israeli chartering, and the link to a clearly Israeli-linked vessel, an Israeli-owned vessel, the Galaxy Leader, which on 19th of November was hijacked by the Houthi movement and detained, indicates and underscored the early threat to shipping, specifically around Israeli link. But the evolving situation and the ongoing shift in the risk to vessels is being demonstrated in the months following, where we've seen a continued targeting use of missiles and drones towards vessels transiting the Red Sea, towards an increasingly unpredictable targeting pattern. One point where a definite statement was made is in early December, when the same rebel Houthi movement stated that they would be targeting vessels regardless of country affiliation that were trading with Israel, so broadening the scope. But again, towards middle of December, we can see that over 50% of the vessels had either an increasingly tenuous or no discernible link to Israel, and therefore the breadth of risk to vessels was greatly expanded. We cannot be sure whether this is because the movement is relying on bad intelligence, or there is they are responding to perhaps diversion by more clearly Israeli-linked vessels, but the breadth of threat has definitely increased and continues to increase. We've seen a shift in the international naval response as well. So there's been an immediate deployment from various naval forces. In December, we saw the standing up of the defensive multinational Operation Prosperity Guardian, and the various naval operations, whether individual or through this operation, have successfully intercepted most of the missiles and drones launched from Houthi-controlled territory in Yemen. We again see another step change at the end of December, where an exchange of fire by US naval forces against an attempted hijack of the Maersk Hongzhou resulted in the sinking of 3 Houthi boats together with their crew. And following this, a statement by multiple states that the Houthis will bear responsibility for any further threats to shipping indicated again a shift in the tone and made airstrikes more likely. Indeed, airstrikes is what we then see overnight on the 12th of January, where airstrikes targeted 60 positions at 16 sites, and we've seen further targeting as well. This has again changed the risk to vessels in the Red Sea and around the Red Sea area, with the Houthi movement stating that in the aftermath of these airstrikes, both US and UK shipping would be seen as legitimate targets, and that was not linked to whether they were trading to Israel. When we talk about outlook, what we need to really think about is that the strikes themselves are not have not eliminated, they have degraded, but not eliminated Houthi capacity to target shipping in the Red Sea. The Houthis are capable of resupply, they are highly organized, and they have other means at their disposal that they can deploy. For example, they've previously been able to use in previous years the use of explosive-laden drone boats. And they have a continued intent to target shipping, both because of their stated aim to support Palestinians in Gaza and for other domestic or regional priorities. So we can see that there is an ongoing shift in the broadening of risk to vessels. This has been most clearly demonstrated in yesterday's incident targeting a US-linked vessel in the western part of the Gulf of Aden, deep offshore Yemen. And it is going to be something which continues to be a fast evolving and nuanced question for many people on this call and in the shipping community. And I think that's what we really need to bear in mind, is that it is necessary to look at this on a case-by-case, vessel-specific basis. Indeed, Control Risks is supporting clients to try to understand the specific risks and the changing risks to vessels considering transit through the Red Sea, not least for the immediate concerns around vessel and crew security, but also for the longer-term implications, which will be discussed around by the other panelists in this webinar. I'll leave it there for you, John. Thank you very much.
Victoria, before we pass on, I was wondering if I can ask you a question, which is, I mean, we all know that the security situation seems to have changed dramatically following the attacks on the Houthi bases. But prior to that, in the run-up to Christmas, I was wondering how many, give us some idea of the volume of vessels that were going through the Red Sea without being attacked, and were there any particular types of ship that were less vulnerable to attack?
That's a great question, Marie. And the statistics vary. I think the main statistic that we have been referencing is prior to the airstrikes, there was a reporting by Lloyd's List around an overall 28% drop year on year in vessel traffic. The Red Sea has continued to be a busy route. Most vessels transiting the Red Sea have not been targeted, but of course they will have constantly been at risk of being targeted, either by misdirection or by being in the vicinity of an attack by missiles or drones launched by the Houthis. Regarding vessel types, there's the vessels over a certain tonnage, which of course we see reporting on. There have been incidents affecting across vessel types. There's also the smaller vessels, for example, tugs, support vessels, all these ones that we're not talking about, which are also continued to operate in those waters and not being subject to attack either. So I think the main point I would draw is that the risk has not been specific to a chemical tanker or a dredger, but it could be across vessel types. I hope that answers your question.
Yeah, thanks very much, Victoria.
Thanks, Victoria. That was excellent and really interesting, I'm sure, for everybody listening to hear what the current analysis is. Marie, if I could ask you then perhaps to discuss what the sorts of issues that you're having to deal with are at the moment.
Well, you can imagine we've had a huge number of inquiries about deviations to avoid the Red Sea. Some of the questions are simply just seeking as much information as possible about what's going on, obviously from our loss prevention guys. And but many of the questions come into our defence team lawyers, and they're questions about liability and the legal risks if vessels deviate. And of course, there's no one size answer to all these questions.
Marie, if I could just ask, who are you getting these deviation inquiries from?
Well, that's an interesting one, because we're getting inquiries from both owners and charterers, and probably more questions from owners than charterers. But and you might say the kind of obvious thing that often it's the owners that want to avoid the Red Sea, and the charterers that wish to take the usual route, but not always. We've certainly got cases where the charterers want to go around the Cape, and the owners want to take the Red Sea route. For example, the charterers may be voyage charterers, and they may be worried about their cargo. So we're getting questions from both sides. So it's quite interesting. And the first challenge is, of course, that each charter party is different. So we see some with very strong belt and braces protection for owners when they wish to choose a different route if there's some kind of risk to the vessel, and others that have very little protection for owners written in without even a war risk clause. And as well as the obvious con war time and void war clauses that we're going to talk about later that we see a lot of, we see a variety of other standard and bespoke clauses that parties want to rely on. And an additional level of complexity is, of course, added if we're acting for the middle party in a chain and the charter parties are not back to back. Then there's a potential sort of gap in liability. It's not necessarily the case that everything can be passed down the line. So our P&I team are also getting questions about potential cargo claims arising out of delay, and of course questions about P&I cover if the Red Sea route isn't taken. And finally, we've also have some members whose vessels have been targeted. And then, of course, we have to deal with the fallout from that. So the whole legal position is really complex. And the factual position is not what you would call straightforward either, so because it seems to change from day to day. And the risks have really ramped up recently. And so you're looking at a factual matrix that's really time dependent. So it's and to put aside the time, you also look at the risks may be different depending on the type of vessel and whether there are Israeli connections or other connections now US, UK. So of course, people like Victoria can provide you with detailed, up-to-date information on risk. And there's also some helpful guidance from trade bodies like BIMCO and Intertanko on security. You know, for example, advice that relating to AIS transmissions and not to keep it on during transit. But that, you know, there's also advice, this is from the US Navy, that you're at less risk if you transit at night. But of course, if everyone has an AIS off and they're all transiting at night, there's an additional risk of collisions. So it's not easy. And we're also hearing on the ground that on AIS that some owners are leaving their AIS on, you know, similar to when we had the piracy crisis and they would put on the AIS armed guards on board. Now they're posting things like no connection with Israel, no contact Israel, or the one that I found quite surprising was all Chinese crew. Apparently that's something that people are putting on their AIS because they think it's going to protect them from attack by the Houthis. So there are really sort of two schools of thought around practically everything that relates to the this Red Sea crisis. So it's, you know, it is a difficult one, and you know, we have to deal with issues as and when they come up. But I hope that gives you some idea of the sort of ever-changing factual matrix and the complex legal matrix that we're dealing with.
Thank you very much indeed, Marie. That was very, very interesting indeed. Tom, I think now you're going to look at the broad legal framework and discuss in a little bit more detail some of the issues that may arise.
That's right. So as you say, you're going to be looking later on at some of the specific BIMCO war clauses, con war time and void war. But I'm going to outline the general legal framework for considering whether owners are obliged to transit the Red Sea and other war risks areas given the current security situation. I'm going to look first at the position under voyage charter parties, then I'll look at time charter parties. But this is going to be very much a whistle-stop tour because of the limited time that we've got. And I'll mention a couple of authorities during the course of my presentation, but I'm not going to take you to the text of those. Details will be available after the seminar. So before getting any further into it, it's important to stress that the rights and obligations that we're considering arise in contract, and so general principles of contractual construction are paramount. In particular, every charter party has to be construed on its own individual terms. There's no one-size-fits-all answer for every charter party. Charter party must be construed within its own particular factual matrix, and that will obviously include the security situation on the ground at the time that the particular charter party was concluded. And as we've heard, that situation is changing week by week or even day by day. It's also important to have regard to all the terms of the charter party and not just the ones that seem most obviously relevant. And then, of course, you have to focus not only on the language used, but also on the commercial implications of any given construction. And finally, also bear in mind that terms may be implied into a charter party where they are necessary and reasonable. So looking at voyage charter parties, the key concepts here are really, firstly, the contractual route and contractual liberties to deviate. And I might add in at the end the common law doctrine of frustration, which plays a role, I think, or will play a role in a number of disputes arising under voyage charter parties. Contractual route, first of all. I mean, sometimes one sees a charter party, a voyage charter party, which specifies the route for the vessel to take, but more often than not, it doesn't. And in those cases, owners are obliged to take the usual and reasonable route from the load port to the discharge port. There's a rebuttable presumption that that usual and reasonable route is the direct geographical route. And obviously for many voyages, that route will be via the Red Sea. In addition, voyage charter parties typically require owners to perform the voyage with reasonable dispatch, and that means taking the shortest and quickest route, see the Hill Harmony. Again, that will often be via the Red Sea. Then liberty to deviate. Obviously, owners' primary obligation is to perform the contract by the contractual route without deviation. but the Charter Party will often contain express or implied liberties to deviate. In the absence of an express liberty, owners will generally be entitled to depart from the contractual route without being in breach of contract if owners or the master reasonably believe, based on credible information, that the ship or cargo will be exposed to some imminent peril, and the deviation is a step which a reasonable and prudent person would take for the purpose of avoiding the danger. That's the rule in a case called the Teutonia. And the requirements are fairly exacting. In particular, the level of risk has to be high. Owners must reasonably believe that the ship or cargo will be exposed to imminent peril. Of course, many voyage charter parties contain express liberties to deviate, and these provisions are generally construed restrictively so as not to be inconsistent with the main object and intent of the contract. Typical wording, which should be appearing on your screen now, is that found in the GenCon Charter, Clause 3, and many of you will be familiar with the wording of this. I've highlighted the key phrase there. Vessel has liberty to deviate for the purpose of saving life and or property. Now these words probably aren't going to be much use in the sort of situation we're considering, because they probably only permit deviation for the purpose of salving another ship in distress. They probably don't permit deviation for the purpose of avoiding danger to one's own ship. So that sort of general liberties clause that one often sees is unlikely to be of much help. Many voyage charter parties also incorporate the Hague or the Hague Visby rules, and they are more useful. So you should have now on the screen Article 4.4, which provides any deviation in saving or attempting to save life or property at sea, or any reasonable deviation, shall not be deemed to be an infringement of or breach of these rules or of the contract of carriage. And one sees similar wording in other bespoke deviation clauses, such as the BIMCO Liberty and Deviation Clause. The expression reasonable deviation has been construed in a case called Stagline and Foscolo Mango to mean one which a prudent person controlling the voyage at the time might make and maintain, having in mind all the relevant circumstances existing at the time, including the terms of the contract and the interests of all parties concerned. Now that's a less exacting test than the common law test in Teutonia. And in particular, the required level of risk is lower. I thought I'd mention at this stage the common law doctrine of frustration, which is a concept which people often instinctively reach for in this sort of situation. A contract is terminated by frustration where an event occurs after the contract has been concluded, for which the contract makes no or no sufficient provision, and which so radically changes the nature of the outstanding contractual rights and obligations from what the parties could reasonably have contemplated when they concluded it, that it would be unjust to hold them to the terms of the contract. And where a frustrating event occurs, it kills the contract, it terminates it automatically, whether the parties like it or not. Now, a contract will not be frustrated merely because performance has become more onerous or more expensive than the parties expected. It will only do so if the increase is so extraordinary as to make it unjust to hold the parties to the contract. A frustrating event need not even have been unforeseen when the contract was made. In fact, the contract can even expressly provide for the frustrating event. Nevertheless, the event is capable of frustrating the contract if the contract doesn't make full and complete provision for it, in particular where it doesn't make full and complete provision for its effects in terms of the allocation of risks. So any type of charter party can be frustrated, but voyage charter parties are more likely to be frustrated in the present context than, say, a period time charter party. And in particular, a voyage charter party may be frustrated by events in the Red Sea, either where there's no applicable liberty to deviate via a different route, or where there is a liberty to deviate, but going via that longer route would itself radically change the nature of the contract. So, for example, if you have a vessel carrying a perishable cargo that could not be expected to survive a voyage around the Cape without suffering significant damage, that might be a situation in which the voyage charter party was frustrated. Then looking at time charter parties, the key concepts here are really, firstly, the master's obligation to comply with lawful employment orders. Secondly, the master's right to refuse to comply with otherwise lawful orders in certain circumstances. And finally, very significantly, the master's right to delay compliance with lawful voyage orders in some situations. So firstly, obligation to comply with lawful employment orders. Obviously, that's the general obligation of the master. And importantly, an order to follow a particular route, such as going via the Suez Canal and the Red Sea, counts as an employment order. That's the Hill Harmony. In addition, time charter parties usually provide that the owners must perform voyages with reasonable dispatch, and that again means that where the charterers haven't specified a route, owners are obliged to take the shortest and quickest route, which may be via the Red Sea. Obviously, charterers' right to give employment orders is limited by the express terms of the charter party. And where the charterers give an invalid employment order, one which they're not entitled to give, and the master lawfully refuses to comply, it's important to bear in mind that the charterers are obliged at that stage to give fresh lawful orders. It doesn't necessarily follow from the fact that charterers have given an unlawful order that the master can then decide what to do himself. So if the charterers order the vessel to go via the Red Sea and the master lawfully refuses, he can't simply take it upon himself to go around the Cape. He has to wait for new orders. Now, the master's right to refuse to comply with lawful orders. Generally, the master will be entitled to refuse to comply with otherwise valid orders where to do so would expose the vessel to a risk which owners have not agreed to bear on the proper construction of the charter party. And a person of reasonable prudence would refuse to comply in the circumstances. And authority for those propositions are the Hill Harmony and the Hague. And that principle obviously has potential application in the present context. Even more important, perhaps, is the master's right to delay compliance. The master's obligation to comply with lawful employment orders is not one of instant obedience. It's only an obligation of reasonable conduct. And that means that the master is entitled to delay complying with charterers' orders for as long as is reasonably necessary for him to be able to investigate and assess whether compliance might involve a significant risk of endangering the vessel or its cargo and crew. See the Hague. And that principle is of great practical importance at present, where the situation on the ground is evolving and becoming clearer day by day. So, for example, if you're the master of an American-owned vessel with no Israeli connections, it might well be reasonable, in light of the most recent attacks, to wait for a few days or a week to see whether the Houthis continue to target American-owned ships in the Red Sea before complying with an order to proceed through the Suez Canal. So that was a whistle-stop tour of some of the basic legal framework. And with that, I'm going to hand back to John and to have a look at some of the specific war risk clauses that many charter parties contain.
Thanks, Tom. Before we go to Joe, one question that's come in the Q&A that perhaps follows on naturally from your talk is the extent to which an implied indemnity may be relevant if a vessel is attacked while following charterers' orders to transit the Red Sea. I don't know if you have any comments on that.
Yes, well, the general principle is that the implied indemnity covers the consequences of complying with lawful or unlawful orders, but particularly lawful orders, where doing so exposes the ship owner to risks which, on the proper construction of the charter party, owners have not agreed to bear. And so it's certainly quite easy to see that many situations may arise where a vessel having agreed to transit the Red Sea, is attacked or suffers some kind of loss as a result of doing so, and owners are entitled to recover from the charterers under the implied indemnity for doing so.
Yes, but I guess it may involve an analysis as to what risks owners are deemed to have accepted in all the circumstances when they...
Well, absolutely right. And that takes one back to the point that I made earlier, and Marie also emphasised, which is that every charter party has to be considered on its own terms and in the context of its own factual matrix. And that's part of that analysis of working out which risks owners have and have not agreed to bear.
It's a point which has already been made, and which I may make again when I get to my talk. Thanks very much, Tom. Joe, do you want now to take us through con wartime and the void war clauses, please?
Yeah, thanks very much, John. So I'm going to cover the 2 BIMCO war risk clauses, which, if incorporated, will most likely govern the position of whether an owner can refuse to proceed through the Red Sea. And so these are void war, which are used in voyage charters, and con wartime, which are used in time charters. And I'm going to outline what the relevant clauses are and how best to interpret them. And then John will talk about how this can best be applied in practice. And I should say at the outset, I'm going to be primarily considering the most recent 2013 version of the BIMCO clauses, but it is important to look out for any amendments which might be made or earlier versions of these clauses. So both the con wartime and void war 2013 clauses give the owners, in certain circumstances, the right to refuse to proceed through a dangerous area they've been ordered to go through. And the circumstances are as follows. So where it appears that the vessel, cargo, crew, or other persons on the vessel, in the reasonable judgment of the master and all the owners, may be exposed to war risks. And the burden will be on the owners to show that these circumstances have arisen. And that the 3 key phrases here are reasonable judgment, may be exposed, and war risks. And interpreting these phrases, we have some assistance from a 2012 commercial court case of Sir Nigel Tier called Pacific Basin and Bulk Handling Handymax, or more commonly known as the Triton Lark. And so this case involved a time charter, which incorporated the con wartime 1993 clause, which itself is very similar to the 2004 con wartime clause, where the vessel refused to travel from Hamburg to China by the Suez and Gulf of Aden due to the threat of piracy in the Gulf of Aden, and instead proceeded round the Cape of Good Hope. And the question was whether or not the owners had exercised the relevant reasonable judgment. And Sir Nigel Tier considered what the term reasonable judgment meant. And he said the key is for the judgment to be one which was in good faith and objectively reasonable. Now, good faith will always be contextual, but the distinction which Sir Nigel Tier had in mind is one between a decision which is taken out of a fear of safety, whether that be the cargo, ship or crew, and one which is taken for financial reasons. And he noted that this clause could not be used as a device to obtain a financial gain. And it must also be objectively reasonable. So that means reasonable after proper inquiries have been made. And the fact that this is an objective test means that it's not necessary for an owner to actually make all the necessary inquiries, so long as it can be shown that they could have reached the same judgment if they had made all the necessary inquiries. Now, the second issue is whether proceeding through the Red Sea may expose the vessel to war risks, and what's meant by the words may expose. So in the 1993 and 2004 clauses, the con wartime and void war clauses contain the words may be exposed or is likely to expose. And Sir Nigel Tier in the Triton Lark considered that these words must mean the same thing, namely a real likelihood of danger. And he considered this to be less than more likely than not, but more than a bare possibility. And the language of the 2013 edition now just contains the words may be exposed. And this was a deliberate change which the explanatory notes make clear was in response to the Triton Lark's focus on the likelihood of the risk of attack rather than whether the area was dangerous itself. And now there's certainly a debate as to whether the 2013 clause was effective in achieving this goal. But if we accept that it was, the relevant inquiry is whether the vessel is going to proceed to a dangerous area. But it's important to remember that the question can only be answered by reference to the subject vessel. So is the area dangerous to your vessel, not is the area dangerous to shipping generally or some vessels only. So the third phrase is war risks, and this is defined in clause AII of both wartime and void war, and will include a list of name risks. So, for example, acts of war, civil war hostilities, warlike operations. And that risk must also be one which, in the reasonable judgment of the master or owners, may be dangerous or may become dangerous. And what is dangerous will ultimately be fact sensitive and depend on various factors such as the seriousness of the risk and the consequences of the relevant risk. Now, John will be discussing how the reasonable judgment test is applied in practice, but I will just summarize what the rights of the owners are if they conclude that there is a sufficient risk of danger. So under time charters and war time, if the owners or the master make that reasonable judgment, they will be entitled to proceed to or through the Red Sea. They have to refuse to proceed to or through the Red Sea. And if they're already in that area, that place becomes dangerous after entry into it, the vessel is at liberty to leave it. And if there's already cargo on board, the owners must give the charterers immediate notice of their refusal to go through, and charterers have 48 hours to nominate a safe port for discharge, failing which owners can nominate their own port. Insofar as voyage charters are concerned, if loading has not yet commenced, then the master will be entitled to refuse the transit to call in the Red Sea. But if the charter party provides for a range of discharge ports, the owners will be required to notify charterers, who then have 48 hours to nominate a different safe port. If the war risk arises during or after loading, where the Red Sea is the normal or customary route for the laden voyage, then there are two scenarios. So if there is no longer route available, and this will almost certainly be where there's a port call within the Red Sea, Gulf of Aden route, then the owners must notify the charterers of their refusal to proceed. And again, charterers have 48 hours to nominate a new discharge port. And for any additional distance that the vessel is required to travel, the charterers must pay a higher freight rate on a pro rata basis. If there is a longer route to the discharging port, then subclause D will apply, which states that the owners shall give notice to the charterers that this route will be taken. And it appears that there's actually no choice for either party to do anything different here. And again, owners are entitled to additional freight on a pro rata basis. Now, one potential issue that may come up is when the vessel can go the longer route around the Cape of Good Hope, but is carrying perishable cargo, which won't be able to withstand the voyage. And so what happens here? Well, on a literal interpretation of the clause, the owners are entitled and bound to perform the voyage, and charterers have no option to choose a different port. But for obvious reasons, this is commercially unattractive. Alternatively, you might say that this is a frustrating event, since a voyage which will result in the cargo being delivered in a damaged condition is radically different from what the parties contemplated. But the difficulty with this argument is that the situation is a direct result of the parties making express provision for a war risks event. And so the most likely option is the view I would say the tribunal is most likely to come to if faced with this question, is to say that a route which will cause the cargo to perish is not a permissible route to the discharging port. And this requires reading words in, but is surely the only sensible commercial interpretation of this clause. So with that, I will hand over to John.
Joe, just before you pop off, I was wondering if you can say just a little bit more about the your view on the extent to which the amendment to Common Wartime 23 following the Triton Lark really makes a difference to the reasonable judgment test, and how it should be put in practice now as opposed to before.
Yeah, so it's a tricky question,
Yes.
because just to repeat the background, the change in the clause was to replace the words may be or is likely to be exposed with may be exposed. And if we're just looking at the wording, and Sir Nigel Tear's judgment in the Triton Lark, these two phrases actually mean the same thing. So query whether there's been any change. But I think we have to look at the explanatory notes as an aid to construction, which says there is meant to be a shift away from looking at the likelihood of the risk to eventuate against looking at whether the area is dangerous for that vessel. How that's then applied in practice and whether there's any real substantive difference is, I'm sure something John might touch on. So I don't want to tread on his toes too much, but in short, I would say there's unlikely to be many cases which would be, at least my view, which would not be considered dangerous under one but dangerous under the other, or which give the owners the right to refuse under one but not the right to the other. But it moves towards more of a gut feel kind of test, I would say, rather than an intense analysis on the likelihood of the risk occurring. Thanks
very much, Joe.
It's a very interesting question, Marie, and I think that one where there's not necessarily unanimity, even perhaps within the members of the panel. I mean, it seems to me that the point that Joe makes is an important one, that the explanatory notes are an admissible aid to construction. And it seems to be clear from the notes that there was an intention to change the nature of the test. It seems to me that, as Joe says, it's really a shift away from a statistical or probability analysis of the chances of a vessel being attacked. And it's now a more holistic analysis, both of the chances of being attacked and also, I think, the consequences of an attack if it takes place. So anyway, what I'm going to do now is look at what all that analysis means for owners and charterers in relation to a voyage that involves or may involve a passage through Suez, the Red Sea, and the Gulf of Aden. And I think the most important point, and this has been touched on already by both Marie and Tom, is that there's no single right answer as to what parties' respective rights and obligations are. And a careful evaluation has to be made in each individual case. And there are at least three respects, it seems to me, in which the analysis has to be individuated. First, in relation to what the relevant contractual terms are. Secondly, in relation to the vessel itself. So the analysis has to be vessel specific. And thirdly, the analysis has to be time specific. So we can take each of those three in turn and perhaps put a little bit more flesh on the bones. It's obviously most important to identify at the outset what the relevant contract terms are. Now, the starting point is likely to be to see whether a voy war or con wartime clause is included in the relevant charter party. But the inquiry doesn't end there. There may well be other clauses that impact on owners' rights to refuse to transit and may impact on the very important question of who has to pay if a decision to take the longer voyage round the Cape is taken. So the entire charter party needs to be considered. And I think in particular, it's important to look at whether there are any specific clauses mentioning sailing via Suez, either standalone clauses or perhaps as part of the freight provisions in a voyage charter party. It's important to look at clauses that set out permitted trading areas and excluded trading areas to see if there's anything of relevance there. Important, obviously, to look at any clauses dealing with deviation. And important to see whether there are any paramount clauses in the charter party which incorporate either the Hague or Hague-Visby rules, or indeed another set of rules. Again, obviously very important to look at the hire and freight provisions to see whether there's anything of assistance there in relation to the who pays question. And similarly important to look at off-hire provisions in a time charter party. Of course, it's very common to find several different, perhaps overlapping off-hire provisions buried in strange places in rider clauses. And it's important that all the relevant clauses need to be identified, and potentially general exceptions clauses may be in play as well. Stepping back from one particular charter party, it's also important, as Maria's touched on, for those in the middle of charter party chains to consider their position up and down the chain if they are not on strict back-to-back terms, because it may be that a charterer in the middle of the chain finds that rights and obligations to head owners are different from their rights and obligations to sub-charterers. And then also, and I think importantly, it's important for owners or charters, or whichever party has issued bills of lading, to consider their position not just under the charter party terms, but also their position under any bills of lading that they have issued. Because again, it may be that, for example, the rights and obligations of owners as against bill of lading holders are not the same as their rights and obligations against charterers. A different framework may apply depending on whether the terms of a particular charter party have been incorporated into the bill of lading contract. Accordingly, what relevant war clauses or other terms have been incorporated from the charter party into the bill of lading contract. Also, which convention or rules are incorporated into the bill of lading contract, and how any relevant charter party terms interact in relation to the rules that have been incorporated, and particularly the Article 4.4 reasonable deviation provision in the Hague Rules. Digressing slightly, I think there's one point in relation to the Hague Rules, and therefore potentially bill of lading claims, that is quite interesting and isn't really made clear on the authorities. If a vessel and cargo is damaged during a transit, if the decision to transit the Red Sea or the Gulf is a decision that has been taken by shore-based management, it seems to me that there may be an issue as to whether that shore-based decision to take a particular route falls within the scope of the Article 3.2 negligent navigation exception. The traditional position is if a decision is taken by the master to take a particular route, that will fall within the scope of the negligent navigation exception, and owners will be protected. But it is, as I say, not clear on the authorities as to the extent to which that protection applies if one has a management shore-based decision rather than a decision of the master on board. So that is, I think, the importance of, in each case, identifying clearly what the precise terms of the relevant contractual regime are. Secondly, as I say, there has to be a vessel-specific analysis. There may be times when an area is so dangerous that all shipping is affected, and whatever the relevant clauses are, they are engaged for all shipping. But that's certainly not necessarily the case here, as Victoria was discussing. And so there needs to be an analysis of the degree of risk to your particular vessel. Now, that may well involve an analysis of whether there are any relevant Israeli connections. And perhaps going beyond that, whether there are any grounds to think that the Houthis might correctly or incorrectly consider there to be Israeli connections. Obviously, the position continues to develop. So following the naval operations, and in particular the strikes on Houthi bases, it may well now be necessary to consider not merely whether there are any connections to Israel, but also whether there are any connections to countries involved in the naval operations, obviously in particular the US and the UK, but there are other countries that are supporting the naval operations as well. Again, what about the type of vessel? Are any types of vessel more likely to be attacked at any given time? And again, this is, as Victoria was explaining, it's a dynamic situation. So it's not enough to form a judgment, let's say in December, as to whether a particular type of vessel is more at risk than others, and assume that that will still hold good in January or February and so forth. And perhaps another element to consider when considering the vessel-specific nature of the risk is whether any countermeasures or mitigation measures, such as those set out in BMP 5, would be appropriate and effective to reduce the level of risk and danger. Now, I mean, at the moment, where there are a lot of missile and drone attacks, it seems unlikely that adorning your boat with razor wire is going to make much of a difference. But as the situation develops, if there is, for example, an increase in skiff attacks, those sorts of BMP 5 measures might come into play. And then thirdly, as I say, the analysis has to be time specific. The position is clearly evolving and may change rapidly. And risks to different vessels may alter with time. So, as I say, advice that was given in early December may no longer be relevant now, and advice that's given now may not be relevant in a week's time or 2 weeks' time or a month's time as the situation continues to evolve and develop on the ground. One point that arises from the wording of the Con-Wartime clause in particular is that the timing, in relation to the timing of any decision not to proceed towards or through the war risks area. The Con-Wartime clause says that a vessel is not obliged to proceed or required to continue to or through any war risks area. So if we assume that a vessel has voyage orders to proceed from the far, let's say from the Far East to Northern European ports via Suez, at what point can owners decide that they are not going to proceed towards or to the war risks area and divert via the Cape? And can they proceed via the Cape from the outset? It seems to me that in relation to those sorts of issues in particular, it obviously makes sense for there to be communication between charterers and owners. And if owners were to unilaterally decide to deviate from the outset, there might be a very real risk indeed of charterers contending that they had ordered or would have ordered the vessel to proceed to a place of safety to wait and see how the situation developed. So I think that whatever the degree of protection in the clauses, there has to be a degree of sort of commercial reality here and communication and cooperation as far as possible between charterers and owners, if owners don't wish to expose themselves unnecessarily to risk. So pulling that together in terms of practical advice for owners in particular, I think that firstly, identify what the relevant contractual terms are and therefore what the relevant legal test is, and then carry out a vessel and time-specific risk analysis. And it has to be, what is the current risk to my vessel at the time that I am making this decision? And it'll be necessary to ensure that the decision is viewed as reasonable, to ensure that there is as much up-to-date information as possible to hand. So that will involve looking at the internet for information, general media sources, maritime-specific publications such as Lloyd's List, industry guidance that's been given from by bodies such as Intertanko and clubs themselves, of course, and indeed specific advice from the likes of Victoria and other risk analysis providers. And it seems to me, as I say, there has to be an evaluation of the risk in terms of both the likelihood of exposure to risks, but also the severity of the consequences if risks eventuate. And it seems to me that prudent owners should certainly be documenting and recording in as much detail as possible the sources that they've taken into account, informing a judgment as to whether to transit the war risks area or not, and recording the basis of that decision. It'd be much easier to establish the reasonableness of a decision if there is a clear and contemporaneous record of the information that was taken into account and the basis of any decision, whether it is to transit or not to transit. Right, so that's what I was going to say. We've had quite a few questions come in. I appreciate that we've been speaking for nearly an hour, but what we can do is perhaps try to answer a small number of questions. And obviously they'll be available, as I say, in the recording in due course in any event. So one question that perhaps touches on what I was saying is the extent to which events after a decision has been taken are relevant. And it seems to me that what really matters is the situation, the risks as they are at the time when a decision is taken. And I think that the fact that risks may change either way after a decision has been taken illustrates the importance of the point that I was making of having a clear documentary record as to how and why a decision was taken. Because let's say, and I'm sure we all hope that it does, let's say the position were suddenly to improve dramatically with fewer attacks taking place. It would be very helpful for an owner seeking to support a decision that had been taken to deviate to be able to point to the analysis that was carried out at the time the decision was taken. Victoria, there are quite a number of questions that have come in, I think, in relation to the situation on the ground itself. And one question was the extent to which the nationality of crew members is relevant to an analysis of risk. There's something that Marie mentioned in relation to ships saying Chinese crew only on board on their AIS signal. Is that something that you've looked at, whether there are any nationalities of crew that are more at risk than others?
So in instance to date, the multinational crew complement of vessels has been apparent. There's been no indication that a particular nationality has been targeted or even been identified by the Houthi movement in order to base that as a reason for an attack. And I think the indication on the AIS that Marie was referring to is also an indication of the geopolitical meaning of demonstrating a nationality as opposed to in a positive attempt to avoid attack rather than being seen as any particular nationality that would be targeted. That is not to say that were the Houthi movement to be sure that an entire crew was Israeli, that wouldn't be a ground for targeting. But in instance to date and on intelligence that we have, that has not been a factor that has been used as a basis. Okay,
so one question that perhaps Victoria, you and Tom might tackle together, because I expect there's both a legal element to it and also a statistical element, is whether we are at or whether we might get to a stage where the usual and ordinary route for voyages is actually seen as being via the Cape rather than via Suez, because the risks are either so high or so many vessels are taking that route. Tom, do you have a view on that?
Well, the question of what is the usual route is a question of fact. So it can certainly change over time, and one can certainly see a situation arising where, for a particular class of vessels and particular routes, particular voyages, so many will be diverting from the Red Sea route to the Cape route that the Cape route will become at least a usual route for that particular voyage, in which case it becomes one which, unless the charter party says otherwise, owners are entitled to take in the future. But it's very much a question of what the situation is on the ground. Probably what matters is whether or not it's a usual route as at the date when the charter party is concluded. But it's very much a sort of empirical thing. People look at the evidence and see whether, as a matter of fact, the vessels of that class with those characteristics are performing that voyage by that route.
Victoria, do you have analysis as to the number of vessels that are taking the route via the Cape on particular?
No, in short, but it's certainly to say that there is a distinction by vessel type. So we've seen that in response by container ships, but that's been an individual liner decision whether to divert. And we see it increasingly with tankers and bulk carriers. So at some point, as Tom's indicating, it's a question of a tipping point towards it becoming the usual route, but there is no number or moment in time that we can see or that we can identify as a future point that would be the shift to the usual route.
I suppose
just add there that it's important to remember that the test is not whether it's the usual route, but a usual route. So you can have more than one, but it's certainly possible that you can have, half the vessels going via the Cape and half going through the Red Sea, in which case they're both usual routes.
Yes, and I suppose one could obtain AIS data and AIS heat maps and so forth to identify the number of vessels taking each of the two routes. Marie, we had a question in relation to AIS and the question of whether to turn it off or not, and whether the club has, whether Gard has a view in relation to that, and in particular as to whether it may impact on club cover or not.
Yeah, well, it's an interesting question. I mean, I don't know of any kind of Gard view on it, but obviously it could, in certain circumstances, prejudice your cover to turn off your AIS if it's contrary to SONAS. And of course, it's a sanctions red flag. But if you're being advised to turn off your AIS, I mean, there's an exception for that because it's a security risk to leave it on, then I would imagine that any club is going to be pretty sympathetic. It's a different thing if you're being advised to turn off your AIS from if you're turning it off so that you can't be identified and so people can't see where you are in the ordinary world, and not people are trying to target you with rockets.
Yes, Tom, there's a question here about acceptance of risk. I think this perhaps ties into the implied indemnity question, whether there would be a stronger argument in relation to charter parties entered into now after the escalation in attacks, that it might be said that owners are more likely to be said to have accepted the risks of a Red Sea transit now than previously.
I think that must be right. There must be an argument to that effect, and there is a case from the 80s called the Product Star No. 2, where the Court of Appeal certainly found that sort of argument very persuasive in the context of a vessel which had gone, I think, to Basra and was attacked by rockets. But more recently, Mr. Justice Tier considered a similar argument in the Paiwan Wisdom in the context of Calm Wartime, and he wasn't impressed by it. But I think, standing back, obviously the argument is there to be made, and it will always depend upon the terms of the particular contract that you're looking at and the particular factual matrix. But the short answer to the question is yes. You're more likely to be taken to have accepted the risks inherent in going through those waters if you agree to a charter party now than if you'd agreed to one in September of last year.
There's quite an interesting question here, I think, which says, would a clause expressly permitting Red Sea transit, for example, always allowed, hold up against an elevated risk of attack since the date of the relevant charter party? Which, I mean, I think that that's a good illustration of how everything is very specific to the terms of a particular charter party. Was one needs to look at where that clause such as that appeared, and there might well be scope for debate as to how a routing clause such as that interacts with something like Con wartime. I mean, it seems to me that a tribunal would be unlikely to hold that a vessel was required to proceed through an area where the master, in his reasonable judgment, considered it to be a high level of danger to the vessel. But Joe, I don't know if you've got a view on that, or Tom.
Well, I mean, in the context of time charters and Con wartime, you have the words whether such risk existed at the time of entering into the charter party or occurred thereafter. And so I think if those words remained in the charter party, I think you'd have a hard time saying where the master still deems in his reasonable judgment such a risk to be present, that he wasn't entitled to refuse.
If I can just comment on that, I mean, it's important to remember that the question that the tribunal will be asked is not whether the master should have been forced at gunpoint to go through the Red Sea, but who bears the consequences of his refusal to do so. So it's not quite as emotive as it might appear when one phrases it differently. I mean, we always come back to the point that ultimately you're going to have to take legal advice on the specific wording of the charter party. But my impression is that there's certainly scope for arguing that in the sort of case that you've outlined, an LMA arbitrator, or certainly a commercial court judge hearing an appeal, would conclude that the always via Suez, always via Red Sea provision trumped the Con wartime. Well, certainly it was capable of doing so.
Yes, it may be one of those areas where, although it shouldn't make a difference as a matter of construction, one gets a different answer depending on what the degree of risk is at the time that the decision is taken.
Yeah, that's true. Yeah.
I mean, the wording may be sufficiently clear to compel a conclusion that the always via Suez trumps everything else, but it seems to me that depending on the degree of risk, arbitrators or a judge may be reluctant to reach that conclusion if it leads to the further conclusion that a vessel is obliged to stand into danger. We've had quite a few questions, I think, relating to marine insurance. But I think I fear if we were to broaden the discussion into insurance implications, we'd probably be here for at least as long as we have been already. But it may be that that's a topic for a further seminar. Tom, I don't know if any questions have caught your eye, or Marie have caught your eye on the Q&A.
Well, I wanted to ask a question which I don't think came up in the Q&A, but I was interested in anyway, which was for Victoria. Do you see? Obviously, we've been focusing largely on the southern Red Sea, but we know that there have been attacks in the Arabian Sea connected to this particular conflict. Do you see any particular pinch points in other parts of the world or in other parts of the region which are likely to be to come to prominence in the coming weeks and months if this Gaza conflict continues to spread as it seems to be doing?
Yeah, it's a great question, Tom. Thank you very much. And I think it's a great moment to say, because maritime is so global, that we do always have to keep looking at the elsewhere. So in the last few days, we've seen the seizure of the St. Nicholas, the ex-Suez regime, by Iranian forces in its diversion to Iran, demonstrating the continued potential for Iranian forces to secure and operate across that strategic strait in the region. So that's certainly one to watch, and that would of course extend into the Gulf region and out towards the Gulf of Oman as well. If we talk about the Red Sea route, we've got the constructed canal, which is the Suez Canal, but we've also got the Panama Canal, where drought conditions have changed the number of vessels able to transit, forcing operators to consider whether they can take alternative routes. But then, whilst you may be aware and have your operations ready to operate in this part of the world, you then need to take into account risks which would come into play elsewhere. I can go on and on. Certainly in Europe, we've got the Baltic region. The Black Sea is another area of concern. I think I would just end with this actually by highlighting that Turkey's consistent application of the Montreux Convention has meant that there's been a limitation on the number of mine clearance vessels which have been able to enter the Black Sea to assist with mine clearance operations, ensuring that the effort to make that a secure space for vessels remains in the hands of the existing assets in the region and the state's ability to cooperate to manage that particular indiscriminate threat to vessel operations. I can keep going. There are so many, but I think I will leave it there because we're so over time.
Yes, I'm afraid we could probably carry on for most of the rest of the day, but I think we probably need to wrap it up there. So I'd like to thank everybody who has attended the webinar. I hope it's been of some interest and use, and I'd like to thank very much indeed Victoria and Marie for joining us today. It's always, I think, really helpful to have a view from outside chambers on issues such as this, both to hear the very practical real world problems, Marie, that you're facing, and Victoria, your explanation and analysis as to what the problems on the ground actually are has been fantastically helpful. So I think we shall end it there and say goodbye. Thank you very much.